Hello, everyone. Thank you all for joining us today for our Performing a Complete Vendor Contract Review webinar. My name is Jessie Redmond, and I will be your host. On your screen, you should see multiple widgets that you can use, including Ask Question, Media Player, Slides, Related Content, Speaker Bio, Request Demo, and Help. If you're unfamiliar with our webinars, all the widget boxes are resizable and movable, so feel free to move them around to maximize your screen space. At the bottom of your screen in the toolbar are icon buttons you can use to show and hide the widget. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner of the widget. If you experience any issues or have technical questions, you can use the Help widget or submit them along with any other questions through the Ask Question widget. Don't worry, we do capture all questions throughout the session. We will be answering some during the webcast, but those that we do not have a chance to answer live, we will address with you via email. Today's live session is eligible for 1 CPE credit. If you wish to receive this credit, please remember to answer all of the polling questions that will appear on your screen during today's presentation. You will also be sent a follow-up survey link 24 hours after the live session that will need to be completed in order to receive the CPE credit. With us today, we have Kelly Vick, VinMinder's president. She will walk through how to review a vendor contract and the key terms and conditions to include. You will see a link to a copy of today's slide deck, a link to our website, a link to our samples library, links to our What to Include in Critical Vendor Contracts ebook, our Setting a Breach Notification in Cyber Right to Audit Expectations in a Vendor Contract infographic, our Vendor Contract Considerations Sample Language and Recommended Tips ebook, as well as a link to our additional resources, all within the Related Content widget. With all that being said, I would like to hand it over to Kelly. Kelly, the floor is yours.
Thanks, Jessie. So for today's session, we actually have quite a bit that we're going to cover. We're going to take a look at some key elements of the contract, especially as it relates to your critical vendors. We're going to talk about fourth parties quite a bit, actually. We're going to talk about key performance indicators, which is, become more and more relevant since 2020 and continues to be very relevant. And then we'll talk about some exit strategy and the processes around that. We are going to take a look at some examples of common contract language and clauses, and then we'll round it all out with some key takeaways. So let's go ahead and get started. We have so much material to cover in today's webinar, but I want to start with a very brief overview of the 5 phases of vendor contract management, since we're talking about contract management. Just take a quick review of this. The first phase is, of course, that internal planning, who needs to be involved in the selection of the vendor and the authority to sign the agreement. Then comes the negotiating, creating and drafting of the agreements between the two parties. Will you use standard templates? Will you use their template? Do you have external or internal legal counsel reviewing? And then that approving and executing, and you certainly want to make sure that your governance documents, your third-party risk management program documents identify who the authorizing parties are to execute these contracts. And storing, this is a very important part, is making sure that those contracts are housed in some location, hopefully a centralized location, so it's easy accessible to the people who need to access it, and you can always find them. And then the ongoing managing of that contract throughout the life of the relationship. It has a life cycle, just like the vendor's relationship itself has a life cycle. And of course, I just mentioned this on the last slide. It happened to be part of step 2 or phase 2, but I wanted to bring it up again just to bring some awareness to the fact that negotiation is really an important part of the contract management process. It's not advisable to accept the first contract that you see or to just sign on the dotted line without some type of review, even in situations where you don't have an opportunity to make changes or offer red lines. Maybe it's an online subscription agreement. you should at least know exactly what is included in the document that you are agreeing to. But when this opportunity does present itself for negotiation, it is absolutely something that should be done. You should go into the contract with this relationship, with this vendor, knowing what provisions are important to you in the contract. Don't expect that all of the provisions that are even required by the regulatory agencies upon which you fall under are in the contract. It is not necessarily going to be the case. So absolutely reviewing that contract and working through the negotiations is vital. It is very important that both parties are a part of that process and in the end walk away with an acceptable agreement to both parties. Okay, so with that quick review out of the way and thinking about the best practice of negotiating the contract language, I'm going to talk about on these next several slides some critical elements that need to be included in every contract, should be included in every contract, and certainly are the critical elements that are required by the financial institutions regulations, and in addition to that, this presentation has been updated to ensure that we're covering those that are part of the interagency guidelines that was just released in June. So the first one up is to make sure that the contract clearly outlines the scope of the services. Regardless of what document this might be in, maybe it's in a master agreement, or it could be in a statement of work, or it could be in an order form, whatever it is in, you clearly want to understand, what services you are purchasing or products you are purchasing, what type of maintenance and support is included with that, maybe even timeframes around the implementation of those services. Certainly a critical element of your vendor contract, certain vendor contracts anyway, would be performance standards and quality or adequacy. So these are sometimes known as SLAs, oftentimes known as SLAs or service level agreements. It is a critical element that you want to make sure with those vendors, those third parties that are providing a service to you that ultimately is providing a service to your customers, you certainly want to make sure that these SLAs are in place because they are impacting your performance, which then reaches down into your customers and your reputation. So make it very clear, and we're going to talk about SLAs in just a moment. I just want to make it very clear that these SLAs or performance standards are certainly a critical element that should be included. Your contract timeframes, this covers your effective date, your termination date, notification period around termination dates. This is one area of the contract language that can be ambiguous if you're not, if you don't have it detailed out as clearly as it needs to be, so that absolutely both parties understand exactly when the contract starts, when it ends, how it can end, what has to happen to make it end, what happens after it ends. There's a lot around contract timeframe, so this is certainly a critical element. Another very critical element of the contract is around security and confidentiality provisions. And in this provision, you want to make sure that the provision, whether it's your templated contract or a contract that's being handed to you by another vendor or by the vendor, you want to make sure it's covering things like data ownership, who owns the data and what happens to it upon rest, upon transition, upon termination. You need to understand how your data is safeguarded and what controls that vendor has in place to help prevent against breaches to your data or potential breaches to your data. You do want to most likely cover data destruction when, at the time of termination, when you would that you would require data destruction, and what you would require as a part of that You could very well have some geographical limits on where your data can be stored and whether your data needs to be segregated from other data that your vendor would have from other customers. This is a very critical topic these days with all of the breaches and cybersecurity issues that have been surfacing. So this is obviously just the tip of the iceberg as it relates to data security and confidentiality. So be sure to spend the appropriate amount of time looking at that information within your contract. So we're going to talk about 3 here. We're going to look at audit requirements. Are you going to require that you have the right to audit this third party? If that is important to you with this particular relationship, you should definitely ensure that that language is included in the contract. It may be a very generic statement without any specific particulars around it as far as timing, what is to be audited, and if it is specific language, you should also remember to require that the fourth parties who have access to your data are included in that audit process if you choose to put it in the contract. Again, it is a required part for critical vendors. Reporting is another, and you probably could label this a number of ways, but basically just understanding what you have access to know how your vendor is supporting you. Do you have performance reports? And if you have SLAs, then those SLAs should define the performance reports that you do have. What type of information, what type of data do you have access to contractually that will ensure that the vendor is performing as you expect them to perform and in the ways that you expect them to? And then thirdly, compliance with laws and regulations. I see this most often as a generic, just an overreaching statement that depending on the location, the services and the regulations, you may have some very specific items that you want to put in there, or it could be a very broad statement with any laws and regulations. So in today's world, business resumption and contingency planning language is absolutely a must-have in your third-party contracts. Again, if you are working with a critical vendor, a vendor that is high risk, that has access to data, supporting your customers, providing very critical services to you, then you want to understand the strength that they have in ensuring that they will be around to do exactly what you're expecting them to do. So in the contract, you are looking for clear details and plans around disaster recovery, business continuity, business resumption. You want to make sure that the provision stipulates that you receive these on an annual basis, that even possibly you participate in annual testing of their plans. Just understanding what their recovery time objective is, and whether that meets your expectations based on based on the service that they are providing you, is another critical part of the contract that you may want to have included. Again, that will absolutely depend on the vendor and the service that they are providing. Reviewing subcontractors. Listen, subcontractors, fourth parties, we're going to talk about that again in a moment. That will need to be covered in multiple places throughout the contract, but just adding this as a provision, a critical element of the contract to ensure that it is covered throughout, whether it is covered as part of the audit, covered as part of gathering the appropriate due diligence from the fourth parties through the third parties, ensuring that your third party has an appropriate review process in their third parties, your fourth parties. All of those pieces may be covered, some or all of them may be covered within and throughout the contract to ensure that subcontractors of your vendors are scrutinized and managed as you are going to manage your third party and you would expect them to manage theirs. Another critical element in the contract to look for is ownership and licenses. It's important to make sure your rights are protected and outlined. This language should clearly describe the type of ownership and license you are being granted and what and how each party is allowed to use each other's data or system or documentation or any other intellectual property. You probably want to clearly state how you can use each other's names or logo or trademarks or any other copyrighted material. And if you're receiving a deliverable from this vendor, then the contract should also state what's expected, who has ownership rights with that deliverable. At a minimum, the contract should probably give you a worldwide perpetual royalty-free license to use those deliverables. But again, that's something that needs to be considered. Taking it one step further, if you are purchasing software, when appropriate, you should probably establish some escrow agreements to ensure that you have the necessary or access to the necessary source code under certain conditions. And reps and warranties is another critical element. You know, most contracts have the general as-is statement, but it is common to have some reps and warranties that can be detailed. Things like, you know, both parties are, you know, will conduct services in compliance with applicable laws. The software will be free of malicious code, etc. The staff is appropriately certified. Both companies are duly authorized. These are just a couple of examples of common reps and warranties. An appropriately written indemnification clause will hold your organization harmless from liability due to a negligent third party. Indemnification for infringement or breach of confidentiality or misuse of services, maybe gross negligence, these should all be included in the indemnification clause. As well, there should be a standard statement that is indemnifying against inconsequential and indirect damages. And hand in hand with what you are indemnified against is how much you are willing to lose or be on the hook for should the third party fail to perform. Basically, what is your liability limit? Determine whether the proposed limit, if it's a contract that's being presented to you, is proportional to the amount of loss you might experience because of their failure to perform or comply with applicable laws. Also determine whether it's proportional to the contract value and the data at hand. You'll likely find that your liability differs between contracts because depending on the relationship that you have with each of these different vendors, that contract value and the data at hand could be different. Something to consider for limiting your liability is carving out for certain provisions like infringement, breach of confidentiality, indemnification. These are common requests to be carved out. This is certainly an area, both of these are certainly an area, but definitely liability limit, that are typical negotiation areas and ones that I would encourage some, I guess, involvement from your legal team. Be sure to look for ownership and license information. It's very important to make sure that your rights are protected and outlined in the contract. The contract language should clearly describe what type of ownership and license you are being granted, and that the language covers what happens while you had the contract and what happens after you have the contract, after termination, as far as it goes with ownership and license information. And it may be important to you to also include a requirement for establishing escrow agreements to ensure that you do have necessary access to source code in the event of certain conditions. And then look for reps and warranties. There's generally an as-is statement. It's very common with reps and warranties, but then there are some that should be detailed. Some of those are things like the software will be free of malicious code, viruses, worms, etc., that both parties are authorized in good standing to enter into this agreement, especially if they are providing a service for you, that the staff is appropriately certified to perform the duties. Things like that are warranties that you may want to have outlined in the contract. And then this is a catch-all page of everything I didn't fit on the other 6 or 7 slides. These are just some additional provisions you should make sure are included in the contract. I may have actually covered some of these already. If I didn't, or if I did, I apologize that they're on there twice. The bottom line is there's lots of clauses to include in a well-prepared contract. So take the time to review the contract to ensure that these very important and critical elements of the contract exist, whether it's in your template that you're using and presenting to your vendors or a contract that your vendor is presenting to you. And I think at this point, Jesse, this brings us to our first poll question.
And this brings us to the first poll question of the day. You should see the poll question now in the slides area. If you have any issues, please feel free to send us a message using the Ask Question widget, and we will be happy to assist. As a reminder, if you wish to receive the CPE credit for today's session, you must answer all poll questions and be in attendance for the entire live session. This poll question is, who is responsible for contract management in your organization? Compliance or risk management, executive management or the board, information technology, a general counsel, it lies inside a line of business or department such as marketing, etc., or you don't know. Kelly, we have some time now to answer one of the questions that has come in so far. And that question is, what do you do when the vendor's contract is missing provisions that we want added? We get a lot of pushback internally and externally.
So that tells me that you're talking about a contract that is in term, obviously, and either something has changed internally with your organization, or maybe a new regulation or privacy laws, or something has been brought to your attention that maybe the contract that you have with the vendor or third party is not where you might want it to be. This answer is going to be different for everybody, but I think you do try to put an addendum in place with that third party, with whomever you're contracted with. Hopefully there's a good enough relationship with that vendor that you're both willing to put a solid contract in place, even one that is in term. And that can usually be done with an addendum that will address those missing areas in the contract. And it may be two-sided, right? At the time you open the door to do this, it may be that even the vendor has some items that they would like to include in the contract to shore it up. So it's a partnership, and hopefully both parties are working close enough together to allow it to be done.
Thanks everyone for answering that poll question. Here are those results. By the way, you may have noticed reactions such as a thumbs up or heart coming across the screen. If you find this feature distracting, you can turn it off by clicking the 4 arrows in the top right-hand corner of the slides widget, which will expand the slides to full screen and no longer show the reactions. Before we move on, in the related content widget, you will find a helpful resource to reference, which is our What to Include in Critical Vendor Contracts ebook. With that, Kelly, back to you.
So we're going to turn our attention now and focus on fourth parties and contracts. Your third-party vendors, their subcontractors, equals your fourth parties. And one critical thing to remember here is that you are not contracted directly with these fourth parties, so it is very important that you have them solidly addressed in your contract with your third party. So we'll cover a few of the provisions in these next few slides that you will want to be sure to cover this off in. And here's a few listed on here on this slide to talk about, and that is that you're requiring your third party to actively manage their third party to the same standards that you are managing them. So you want your third party to have a vendor management program or a vendor risk program in place that looks at things like the business continuity and disaster recovery plans on their third parties, their information security and privacy program, whether they are compliant with the applicable regulations and laws. You want to make sure that your vendor is performing periodic reviews on those third parties of theirs, your fourth parties, and requiring ongoing monitoring just like you are of your third party. And whether their publicity requirements with their fourth party, whatever it is you have in place with your third party, you want to make sure that goes down into the fourth parties as well. So basically what you're saying here is you want to ensure that your third party has as thorough of a third-party risk management program in place with their third parties as you do with them, so that it reaches into your fourth party. So continuing on, looking at fourth party vendor contract requirements, for critical subcontractors, it's likely that you may want to have a provision that requires your approval before any changes are made with that fourth party or subcontractor. You may have a provision that just states that you're aware but not require approval, but it depends on the relationship and the service that you have. So you may want to go that far. Another is that right to audit. We've talked about right to audit a couple of times already today, but you also, if you're requiring a right to audit on that third party and they're using a fourth party, they're using a subcontractor, you want to ensure that that language is such that it requires that third party to also reach into the fourth party as part of that audit. If it's important, imperative to you with that relationship to ensure that it is a thorough audit, then it needs to be inclusive of any subcontractor processing that is done to support you as a part of that contract. Adverse effects. Your reputation depends on your third party's reputation, and their reputation depends on their third party's reputation. It's a vicious cycle, so you want to be sure that any adverse reputational, legal, or financial events that are related to your fourth party are addressed in contract language that, you know, would stipulate timeframes of notification, of maybe cure periods, maybe possibly even termination or exit rights as it relates to adverse events that may occur with fourth parties, something to consider in your contract. Ongoing monitoring requirements. I mentioned a slide ago that you want to make sure that your third-party vendor has a thorough vendor risk management or risk management program in place for their fourth parties, but part of that is to require that they continue that on an ongoing basis and not just a one-and-done thing. So you may include in your contract that the third parties are responsible for gathering that ongoing due diligence documentation on the fourth parties for your benefit, for you to review, to assess that fourth party just as you are assessing them. Your non-disclosure agreement, which is probably a separate document from your contract actual agreement with your third party, should also extend to any fourth parties, because again, the whole purpose of that non-disclosure is to protect confidential information, and most likely that fourth party has access to some of that same confidential information. And we'll close out this section looking at indemnity and insurance requirements may need to reach into your fourth party as well. If you're requiring some specifically a level of cyber insurance coverage from your direct vendor, your third-party vendor, it may be necessary that that stipulation expects them to have that same level of insurance coverage with their fourth parties. Right to perform activities offshore. This is a pretty big one and can get lost a lot of times. So especially if you're not fully aware of all of the fourth parties that are touching your data. So you certainly want to understand from your vendor, again, what fourth parties are using, and understand and restrict in the contract if it's a requirement for you that that data is to be housed domestically, wherever domestically is. But just know that that is a provision that you may want to expand on in the contract. And then that destruction of confidential information, when you exit the relationship and you've asked for all that data back and you've asked for a certificate of deposit to verify and validate that it has been destroyed, needs to also reach into that fourth party, because remember that fourth party has some of the data, maybe all of the same data that your third party has. So don't leave them out when you're talking about that data destruction at termination.
Our second poll question of the day is, Do you ensure your fourth parties are addressed within your vendor contracts? Yes, no, or not sure? Kelly, I have another question here that we could go ahead and answer. And that question is, what responsibility does my company have with managing our fourth parties?
Well, if you are regulated, and most of you on this call probably are, it's likely that the regulators are placing some responsibility on you to know who your fourth parties are. You're not contracted with them, so that presents some challenges because you can't, contractually obligate them directly to do things to provide you diligence information to perform as you expect, but you certainly can do that through the third party who is using that fourth party, and you should do that through the third party. So as you are bringing on new third party vendors, as you are having contracts come up for renewal with those third parties, and you know that they are using fourth parties, and in most cases all of them are, then that's the time to put those requirements in that contract that speaks to their management of the fourth party and your right to gather information through them on the fourth party, because they're responsible for their performance. So that's where your leverage really lies, and you do have the responsibility to know all of the parties that are supporting your customers, having access to your data, impacting your reputation.
Okay, here are those results. Thanks again, everyone, for answering the poll. I would like to quickly direct your attention back to the related content widget, where you will find our Setting Breach Notification and Cyber Right to Audit Expectations in a Vendor Contract infographic. This infographic will help you establish contract clauses, including the right to audit and breach notifications, which are all essential to setting cybersecurity expectations. Okay, Kelly, let's continue with the presentation.
So this brings us to our third agenda item, and we'll take a look at SLAs, KRIs, and KPIs. These are commonly used acronyms, really regardless of the industry, and each is a type of performance measurement or quality assurance. One of the most essential concerns of any contract is for both parties to identify and agree on what constitutes acceptable performance or satisfactory quality related to the products or the services or whatever it is that is being provided by that third-party vendor. So while you are responsible for setting the standards of an appropriate SLA, your third-party vendor is ultimately responsible for adhering to it and meeting the requirements. So for this reason, it is a two-way street. A healthy, successful partnership between you and your third party starts at this point in the contracting phase, working together on the language, including the standards for performance management, and all of that will set the tone for the long-term relationship. So let's dive in deeper to SLAs, KRIs, and KPIs. Okay, so starting with service level agreements or SLAs, this document, which it can either be a standalone document or an attachment to your master agreement, but it should very clearly identify the expected quality, delivery, and performance of your third party. There needs to be some penalties, or should be some penalties associated for non-compliance, and likely you negotiated that during the contracting phase. If you did negotiate it in, then it needs to be very clearly defined in the contract so that there is no ambiguity or misunderstanding on what is considered a missed SLA and how compensation or penalties occur. Penalties, when included, are generally monetary, either in the form of discounts on the next invoice or fines that would be billed to the vendor, or credits or something like that. But penalties can also be non-monetary. For example, if they continue to miss these SLAs, then most likely that vendor knows that they've lost the right to compete for more business with you. So even if you don't have monetary penalties in there, there's generally ultimately penalties. If the SLA is written properly and the SLA performance is poor and goes uncorrected, then it could ultimately result in you terminating the contract. Hopefully your SLA language has that in there and should have that in there. That is really the most important point to make, is that SLAs are intended to hold the vendor accountable for their performance. So it is very important that the SLA be written as clearly and concisely as possible, so that both parties have no mistake understanding what is expected and what happens if not delivered. Let's talk about key risk indicators. You benefit from proactive risk management, from monitoring not only your vendor's risks, but their performance as well. As part of that proactive risk management, you should review things like their performance, as I just mentioned, their reputation, monitor their negative news, certainly review their financial condition. In doing that, you might find some areas where you want further information, further analysis. Basically, in this process, you are uncovering key risk indicators, or KRIs. KRIs are the conditions under which you may request specific root cause analysis to events or incidents, or maybe you just want additional reporting or details about something you've learned about them in your review. KRIs represent bells going off, maybe suggest a risk or a material risk might be brewing. KRIs also should be set at a level that both parties can recognize that they need urgent attention. And KRIs are beneficial for both parties, because while you're generally the one with the bells ringing and want more information, this also provides a vendor an opportunity to course correct before an SLA is breached or penalties are imposed. A really good way to stay on top of this is establishing some quarterly business reviews or some other routine reviews with your vendor, so it gives both parties a chance to share what's going on their sides. And then lastly, we have the KPIs, or key performance indicators. KPIs should be objective, meaning there's a definable measurement that can be supported by data. KPIs generally establish the specific day-to-day activity that is being monitored and measured to assess the performance of the third party. And to monitor KPIs effectively, you need access to reports and data, whether they're provided by your third party, whether you've developed them, or whether they're made available within the software or service. Regardless of how it's made available, for you to actually review and manage these KPIs, you have to have the data. For you to make the best use of the KPIs, you would want someone or multiple people tasked with monitoring them and escalating when necessary. Otherwise, why take the time to establish them and write them in the contract? If you're not going to measure them, monitor them, and report on them and do something about it, then it's really a meaningless language in the contract. And while I said it's best to have objective KPIs, there are times you may need to rely on some subjective ones too. These are the just kind of gut feel examples. For example, maybe your vendor all of a sudden is no longer responsive to you. Maybe they are not keeping established meetings. Maybe you see a decline in their support because of high turnover or a change in management. So these are some subjective or gut feel KPIs that may cause you to want to sound the alarm and begin having some performance discussions with your vendor. I need to point out here, this slide should say KPI examples. Both of these are KPIs, not KRI. So it's an example of an objective KPI and a subjective KPI. So an objective KPI example is software uptime, or it could possibly be a call answer rate, or a error rate, or maybe a number of deliverables that are performed, or transactional performance. These are very specific, again, data things that you can manage and monitor. Subjective KPIs, an example might be suitability. For example, turnover, again, resulted in a poorly matched account manager. Maybe this account manager just isn't knowledgeable, and so therefore you feel like the vendor isn't performing as it should because of this change. A caution here is to use subjective KPIs sparingly, if at all, because it's one person's opinion and it isn't considered fact because there's not evidence behind it. So while it might be a gut feel, it's one that you want to again use very sparingly. So this brings us to the end of a contract, the time where you want to exit the relationship. An exit strategy means leaving the current situation, either after the established contract term has passed or as a strategy to mitigate failure, maybe an unplanned incident or contract default. When we are in the contract negotiation phase and before we ever execute that contract, we do need to think about what will happen ultimately when it either ends on good terms and you're leaving the contract because you want to, or it ends on bad terms. But you need to have thought through that exit strategy to minimize disruption to your business and to your customers. So when developing the formal exit strategy, you should include the people in your organization who are the experts on what to do, and to think about things like, how will your data be destroyed and returned to you? Will you bring the function back in-house, or will you be looking to outsource to a different vendor, or remove that altogether, whatever the service is? What is the timeline of what needs to happen to minimize disruption? You need to consider all the alternatives, whether it would be a slow unwind or a hasty plan that can quickly be put in place. And have that exit strategy reviewed and tested if you can possibly do such. It is unlikely that you have all the answers to these questions at the time you're writing the contract with that new vendor, but it is something to point out that you do want to have thought through these steps so that you at least have documented some of the ideas that you have in mind at the time you're putting that contract in place. From an exit strategy standpoint, you should be using a champion approach. And what that means simply is that each time you have a vendor contract that is up for renewal, that you're going through a mini vendor selection process. It's always healthy to shop, stay current on competitive solutions, and besides being a sound business strategy, it puts the vendor on notice that performance is being evaluated. And when you were negotiating the contract, hopefully you included language to support a transitional period when it does come time to exiting a relationship. If you don't have that in place today for your vendors, certainly keep that in mind for future contracts. A transition clause within the contract would help identify things like the length of time you have to fully exit, that you still have access to data and documents, what each party's responsibilities are during that transition, the process of how it will be done, maybe what level of service they will provide you during that period. Just very important to have that clearly outlined in the contract, especially with these critical vendors that have access to data and documents. Maintaining your data's security and privacy is critical, even during this transition from one vendor to the next. Here's a few things just to keep in mind. One is, how will your data get transferred? Will there be a secure transfer of that? What is an acceptable method of data destruction? Maybe you want to ensure through the contract that a data destruction certificate from your vendor, I think I've mentioned this a couple of times previously, that would be something expected of your vendor, and that is them attesting to the fact that they destroyed all that information that they have, and remember your fourth parties as well. And then think about in the exit strategy what costs might be included in that, and there could be some hard costs for leaving the contract with that vendor. There could be some termination fees. Maybe you terminated early, so there could be some termination fees there. There could be some specific fees for deconverting your data as well. And then there could be some soft costs, and those are just costs that aren't actual dollars, but just costs in time, change, and just up the speed to get up on the new product or the new vendor that you're moving to.
Our next poll question is, does your organization have a current exit strategy in place? Yes, for all vendors. We have some exit strategies in place. No, we have no exit strategy for any vendor, or you're not sure. Kelly, let's go ahead and answer another question from the audience. And this question is there a risk of putting audit rights in a contract and then not performing that audit?
So from my perspective, and I do want to make sure everyone knows I am not a lawyer here, so this is my experience and my perspective, but I don't see a risk in having that language in a contract and not performing the audit. I can tell you from personal experience, we have seen several contracts with the right to audit language that has never been acted on. I think it is a common occurrence that not everyone I guess, expects the performance of every piece of language in a contract. I'm not sure that that's only true for right to audit. It's probably true for lots of other language, especially around SLAs. You see that happen a lot as well. So I think what happens is, you know, we all just get busy. We get our product and service in place between you and the vendor, and as long as nothing surfaces and really triggers any need to act on that language, then everybody just goes on as normal. It's really when something occurs that raises the question or raises questions about that particular vendor and maybe the performance of that vendor that you might act on that language. So I don't see any reason not to act on it. I think it makes a great reason to include the language even if you don't act on it. That's my final decision on that.
And here are those results. Thank you everyone for answering this question. I'd like to mention that you will find our Vendor Contract Considerations Sample Language and Recommended Tips ebook. This resource will help you understand some basic guidelines and sample contract language. Kelly, I'll pass it back to you.
Okay, over the next several slides, I am including some sample contract clauses or provisions. I won't be covering all, but just a few, and please note that these are just examples that I've come across and decided to share. So on this slide, you will see example language or sample language for audit requirements, assignment, and indemnification. On this slide, you see a general clause covering subcontractors and a clause covering general compliance. Here's that disclaimer of warranties that I mentioned earlier and some mutual warranties, and then another clause about warranties. So just 3 various clauses here about how to handle warranties in your contract. And then we just talked about that exit strategy, which should include some transition language in your contract. So here's some sample language around that. So here's a really good one. Of course, there's many ways that a contract can terminate, but here's one around termination for cause. And this is pretty good language, pretty common language to see, and talks about breach notification and a cure period. So this is a good one to reference. And then we have a very simple generic insurance clause language. I've seen much more robust insurance language than this, very specific details, but this is a general statement. And then here's one about license to using trademarks. And the last one is a dispute resolution with an arbitrator clause. So again, these are just some examples. These are certainly not all the provisions we've talked about, just some that we felt were good to share. You will be getting a copy of this presentation so you can pull them out and refer to them and reach into your own resources for finding your own language, whether it's Google or a legal counsel or some other resource. Oh, I feel like I have covered so much in today's webinar, and I hope it's been helpful. So this is just a few key takeaways to cover. So remember to document the process for vendor contract management within your vendor management program or your governance documents. Plan for that negotiation and strategy prior to engaging with that vendor. Clearly identify all of the areas of the organization that should be involved with contract management process, and understand that contract management does not end once you sign the contract. It is an ongoing part of monitoring your vendor relationship. Monitor that vendor's performance to the SLAs. Be sure to look at those KPIs and KRIs as well, so you can anticipate what's going on with your vendor. Understand the terms surrounding notification provisions and the remedy provisions for the agreement. Manage the risk that you identified during the contract management process through all of your ongoing review of your vendor and that contract. Understand the terms around renewal and termination. Those are so critical to understand going in. Actively manage the delivery of that product and service, again, by reviewing those SLAs, KRIs, and KPIs, and make sure that procedures for dispute resolution are clearly defined and that you have put exit strategies in place should it come to that. Whew. And with that, we'll turn it back over to Jessie.
Great. Thanks so much, Kelly. Before we dive into more questions and answers, I would like to thank everyone for attending. I would also like to thank Kelly for her time in sharing some important information. On your screen now, you will see our upcoming webinars. On September 5th, our third-party risk management and the hidden factors of success webinar. And on September 19th through 21st, our third-party risk management bootcamp. We hope you will be able to join us for those sessions. A link to register for those is in your copy of today's presentation slides. Let's now go ahead and answer some more questions that have come in during this session. Okay, Kelly, our next question is, what can we do if we find out one of our third-party vendors did not properly review or vet one of their vendors?
Yeah, and I am sure this happens quite frequently, since managing fourth parties is relatively new concept. But the first way to hopefully prevent this from happening, or help prevent this from happening, is make sure that as part of your third-party program that you are asking your direct third-party vendors to share with you their vendor management program, so that you can see, are they indeed performing the risk assessments, gathering the due diligence, having the appropriate SMEs look at their various audits, et cetera, policy documents, making sure that they have that in place. But if it wasn't done up front, which this is what the question is based on, then you should certainly, work directly with your third-party vendor supplier to require that they do that immediately. Again, it's a request, and you certainly are dependent on them to perform and to do that. And that would depend on the level of risk that that third party presents to your company as to how strong you want to come out with that request. You even could consider it an issue and manage it through a remediation process. There's a number of things you can do, and then going forward, remember to require that with future new vendor relationships that you put in place. So I think there's lots of ways to work through that, but the best way is to go directly to your third party and demand that they get the information. You can also always go to the fourth party, but just remember that that fourth party isn't obligated to give you anything because you're not contracted with them. Again, hopefully they see you as a partner and will want to help in that request, but things to think about.
Great. Our next question. What is a good way to formalize the exit or termination for a vendor?
Well, if you have an onboarding process of onboarding new vendors, then you just kind of work it in reverse. Another suggestion is to, develop a pretty thorough checklist, and if you don't have an official onboarding process, and in that checklist include the termination process. Some actions that you might include in there are things like, why is this being terminated? Have you notified all the stakeholders? I mean, that's some of the most important pieces, is making sure all the right parties know that this relationship is being terminated, and whatever role they have with that relationship needs to stop. Have you scheduled a review with legal, if that's a requirement with your organization, to make sure you have the appropriate termination documentation in place? You certainly want to have that contract management process outlined so that you are notified of termination dates coming up with contracts, so you don't miss out on that opportunity. That's also obviously very, very important, and that you provided the appropriate notice to the vendor, to your supplier, of the cancellation. And that can be different too, based on the contractual relationship. So all of those items need to be considered in formalizing a process. And then it's post-termination, right? What about the data? Are you going to require the data to be deleted, and are you going to require to get a certificate of destruction in place? So it's a pretty thorough list, but a good way to formalize it.
Great. Our next question: what are best practices to track SLAs against deliverables laid out in contract?
So some best practices are, first, to make sure you have a person or party responsible for managing that vendor and the SLAs from that vendor. Making sure that you have assigning that responsibility to a person is really critical, because if nobody has that responsibility, then nobody's probably taking that responsibility. So understanding who has that task is the first thing. Another thing is to be sure that there's clear reporting and understanding how that reporting on those SLAs takes place. Is it automatic? Do you automatically get something? Do you have to ask for something? Who does it go to? How often do you get it? All of that should have been established in the SLA when you wrote it initially. But again, having kind of a process around managing that SLA that includes all that information should help put best practices in place to manage the SLAs. And then, of course, looking for what happens when there is an SLA that is missed. What happens, so that there should be a best practice that you have in place around what is the escalation process when you are aware that an SLA is missed. Who needs to be notified? What are the steps? Do you have an immediate meeting with the vendor? How do you, what's the process to right the ship with that vendor? Things like that. So identifying who the responsible party is, making sure you have understanding of how you are gathering information on the SLA to determine performance expectations, and then having a process in place for escalating missed SLAs. Those are probably three pretty good ways to track SLAs.
Great. Thanks, Kelly. Unfortunately, that is all the time we have left for questions today. Thank you, Kelly, for taking the time to address some of those that came in. Any questions we did not have time to answer today, we will address offline. We would like to thank you all for attending and hope you found today's session valuable. A big thank you to Kelly for her time and content. You can ask even more questions inside of our third-party think tank, an online community that is dedicated to third-party risk professionals and free to join. Just because today's session has ended doesn't mean the conversations and questions must. Post your questions at thirdpartythinktank.com and see what your peers have to say. In the community, you'll find thousands of free educational resources, including ones related to vendor contract management. If you would like to become a member of Third Party Think Tank, you can register on the site or shoot us an email and we'll get you registered and send you a link to set your password. We did record today's session, and that recording link will be provided to you in a follow-up email that you will receive tomorrow afternoon. Also in that follow-up email will be the survey link for you to request a CPE credit. On behalf of Inminder, it has been a pleasure. Thank you and have a great rest of your day.